Wait just a second. Okay, Mr. Saunders, you have 4 minutes.
Thank you, Your Honor. May it please the Court, my name is Dylan Sanders. Hopefully I will not cut into the 11 minutes that Ms. Goodhart's going to use to address the 21E issues.
Well, you won't, because you're going to stop after 4 minutes.
Thank you. Thank you. I'm going to spend 4 minutes discussing why the trial court was in error and should not have granted JNOV on and overturned the jury's verdict that TJA's liability extended for the entire 25-year lease term and not just to the 2 years that it was actually in the property. The judge made several errors. First of all, Your Honors, he rolled up his sleeve and he got into the evidence. And he weighed that evidence, and the weight he gave that evidence was not in favor of the trust.
But if he didn't get into the evidence, if he ruled on it as a matter of law, which I believe that it's reasonable to consider that he believed it was a matter of law, then as a matter of law, he ruled that TJA only had responsibility for the 2 years that it was a tenant.
Correct.
Even aside from any of the facts.
Correct. We believe that he started with all of the evidence and then got to that ambiguity, but I can address that ambiguity right up front if that's what Your Honor is suggesting.
Because it seems to me that he was and could have decided as a matter of law that the lease was not, that the agreement was not ambiguous.
Well, we submit that he could not have found that.
Okay.
And should not have found it, and it was colored by his view of the evidence and all the discussion, pages of discussion that he gave and weighted the evidence. And most crucially, he took a piece of evidence, and it's this evidence that we submit could have sustained the jury's verdict in addition to other evidence. He took 10 words, which were, I can do that, I certainly will give you that. Those are the words that TJA's representative, Mr. Earl Lewis, said to Mr. Dussel, the trust representative, when Mr. Dussel said, I want an indemnity that covers the 25-year lease term. We've had a number of tenants. I don't know who to chase. You're leaving. I want an indemnity that covers your 2 years and the other 23 years.
Mr. Sanders?
Well, let's say it's excuse me.
Oh, quite apart from whether he did or didn't weigh the evidence, you do have this issue. Just say there was no extrinsic evidence. You do have this issue, though. I know you say that lessee isn't defined, but the first paragraph of that termination of lease agreement says, I'm not going to get the name right.
That TJA as lessee.
As lessee, capital L, and then all the way through, capital L lessee appears in the agreement.
Absolutely, Your Honor. TJA is identified as lessee in that first paragraph, but in contrast to the other terms which are limited in that contrast, it is not defined and limited by the convention that the contract itself uses.
But it's also singular every time.
That is correct. So we contend that it means different things at different times. And that even if you say it's limited to lessee, that still doesn't solve the other ambiguities. It still doesn't solve the fact that the lease says the liability extends during the term of the lease. If TJA was limited to lessee, why didn't it say, could easily have said, it's TJA's 2-year tenancy. The other place that the ambiguity is created is that there's a carve-out for all liabilities that arise prior to the lease commencement date, prior to the 25-year lease. And the implication of that is necessarily that liabilities which arise after that point in time are included. No need to have that carve-out, and in fact, just no need to have that carve-out and no need to say during the term of the lease if that was the party's intention.
Your point is that however strong that word lessee may be, it is made ambiguous by these carve-out provisions.
That's correct. Neither party can resolve these ambiguities. I'm the first one to say.
If your position is adopted, then how do you answer the question, if the trust agreed to pay the lessee a $75,000 termination fee, was that then to be shared with all TJA's predecessors?
Absolutely not. The lessee, this is the last lessee, the lessee with the power to terminate the lease because it stepped in the shoes of its prior predecessor its predecessor, it stepped into its shoes, and it was at the end of the line. It's the only one that had the power to terminate the lease, and it terminated in exchange for that $75,000.
Thank you, Mr. Saunders. Your time is up.
May it please the Court, I'd like to note at the outset that with respect to the 21E issues that I will be addressing, the trustees are in the position of the appellee, and we're arguing first because we were the plaintiffs below. The defendants have raised such a myriad of challenges to the final judgment on the 21E counts that it won't be possible, I don't think, for me to address them all here, and I will have to rely on our briefs and the briefs of the amicus parties, the Attorney General's office.
Are you addressing the fees?
I was not planning to, but I would be happy to if
Go
you're
ahead. I just have a sort of procedural question, whether the amended decision of Judge Billings regarding Electron not having properly pleaded applies also to TJA.
Yes, actually, Your Honor, I do plan to address the litigation fee awards and also the prejudgment interest.
Could you
So
answer
let
that
me
question?
do that.
Because
Yes.
if you read it, it seemed to me that he says it only applies to Thermo Electron, but logically it applied to Thermo Electron and TJA, I thought. Maybe I'm wrong.
I think not, Your Honor. And the
Okay.
reason is that with respect to TJA, which was the lessee, the trial court pointed out that at the time the trustees brought the claim, they had a good faith reason to believe that TJA had used and stored trichloroethylene at this property. And that good faith basis was based on the statement that Earl Lewis of TJA said to
I
Mr.
understand all that,
Dussel.
but when he changed his ruling simply because the defendants didn't plead in their amended answer.
I think the reason, Your Honor, is that he already had an independent basis for finding that there was no ground for a Section 4AF judgment against TJA. But logically, the failure to plead would apply to both, would apply
That's
to
what
all the defendants. And that is
Okay,
really,
all right.
I think,
So
the
it comes to
critical
the same
point.
bottom line.
It's the same bottom line, and all of these defendants, as the trial court finally realized, all of these defendants failed to plead a Section 4AF claim, and it's the trustee's position that's fatal to the claim out of the box. There are additional reasons why some of the defendants on the merits would not receive fees anyway. Let me begin to address the prejudgment interest issue, because I think that's an important one here in the context of this case. The defendants challenge the award of prejudgment interest because they say that instead of having it be adequate, that the jury made findings for each of the calendar years at issue of when the actual costs were incurred, that prejudgment interest could not be awarded unless the trial court forced the jury to make specific findings as to when each of 188 individual invoices were in the first instance paid by the master trust that controlled the various subsidiary trusts, of which the Lincoln Street Trust was one. And
Was it the last day of that year? Is that the
it
date?
was the last day of the year. And the reason why the trial court chose the last day of the year from which to calculate interest was to be generous to the defendants and to avoid any windfall to the plaintiffs. And the choice that the trial court judge had, in effect, was either to award no prejudgment interest, despite the fact that Fisher, with 100% of the equitable responsibility and a 13-year-long response clause and a 12-year-long litigation and running, has deprived the trustees of those response costs for all those years, to either award no prejudgment interest as the defendant's position, or to make the equitable adjustment, which we submit is amply warranted under the rule of Sterilite, which says that the court may make an equitable departure from the strict reading of the strict language of Chapter 231(6)(b), where it's appropriate to avoid a windfall. In fact, if the statute were applied literally, the trustees would get a windfall because we would get prejudgment interest dating back to the date when the suit was brought, even though many of the costs weren't incurred until later. So what the judge did was to avoid that windfall, but also to avoid a complete forfeiture of prejudgment interest, and we submit that's well within Sterilite and St. Paul, and also there's precedent for it in this court's decision in the O'Malley case, where a annualized basis for calculating prejudgment interest was used. Now, I'd also like to spend a little bit of time on the cluster of issues that relate to the litigation fee awards against Fisher, starting with the fee award based on Section 15 of Chapter 21A, and that is the most straightforward route by which the fee award is justified. And I'd also point out that the amount of the award is an amount that was stipulated to by the parties as being reasonable. So the amount of the award is not in question. It's just the basis for the award. This court's decision in the Martinetti case is the controlling case on how to interpret Section 15 of Chapter 21A. And what the Martinetti case makes clear is that for a plaintiff property owner who is a strictly liable party under 21A, for a plaintiff property owner to recover fees under Section 15, they must prove the following. They must prove that they have a zero equitable share of the responsibility, and that means that they must also prove that they did not cause or contribute to the release of the contamination at issue. We have a special jury verdict that reflects
You have a
the jury
verdict
made
that's
those
100%
findings.
against Fisher and 0 against you.
Exactly. And the Fisher challenges that verdict and that judgment and suggests additional findings need to be made about fulfilling the goals of the statute. I suggest that that's not the law under Martinetti, but that even if it were, the trial judge took care of that by going further and making the necessary findings. Secondly, the trustees have an independent ground for their litigation fee award, and that is Section 4A of the statute, which has to do with bad faith conduct during the mandatory pre-litigation stage of the case. I'd point out, obviously, that if Your Honor, if the court affirmed the Section 15 fee award, you need not get too deeply into the merits of the Section 4A claims, but that judgment also ought to be affirmed on that basis, I submit. Fisher challenges the trial court findings and says that they're clearly erroneous. And if you read the trial court's judgment on the 4A claims, it's a very clear, strong decision based on detailed, extensive...
Except for one question that I have. I have a struggle understanding how Judge Billings found that you didn't know that you didn't have a basis for suing the one company that I think it was TJA, when he found a basis on the statement from Lewis that they may have used TCE. But he then discounted, it seems to me, Rudman's statement that Rudman, knew by the time suit was filed that TJA had not contributed to the contamination.
Well, I think Mr. Rudman's statement was not entirely consistent with either Mr. Lewis's statement or Mr. Dusel's statement.
Are you saying it's a question of credibility?
I am, and it's a
Okay.
finding of fact that the trial judge made after hearing those witnesses.
Okay, thank you.
Fisher does not specifically point to any particular finding in the trial court's decision with respect to Fisher's own bad faith that is not amply well-grounded and well-supported in the record. The trial court's decision in many places cites to the particular trial exhibits and the particular testimony that bad faith finding is based on. And again, this court ought to respect the credibility determinations and the very clear conclusions that follow from that on the Section 4A judgment against Fisher.
But I understand that the judge didn't believe Rudman, but what motivation would an attorney have to stand up and say in court that he didn't have a basis for filing the demand letter, the notice letter, and the complaint?
Well, I don't think he said that at all, Your Honor. I think what Mr. Rudman said was that at the time the demand letter was sent, he personally did not think that TJA had used and stored TCE at the property. He did believe that TJA was a liable party, and he also believed that TJA had the contractual obligation.
I mean, was liable derivatively from a...
Derivatively. And there is an argument for that, which ultimately was not presented for the jury. But Mr. Rudman certainly didn't say that he didn't think there was a good faith basis for including TJA. It had to do with when he believed the TCE was released. And the testimony was that Mr. Dussel had a different understanding based on what TJA's principal had said to him. So that is the evidence which I think makes it abundantly good faith to have included TJA in the case at that point. And the court must remember, at this point in time, the trustees had asked for information from all of the defendants and been stonewalled. The statute of limitations was steadily eroding, and we have an enormously complicated web of related corporations here that have merged and gone out of business and spun off subsidiaries. And it took quite some time to understand all of that web. We certainly didn't know at the front end who was responsible and who was not. The last thing, Your Honor, is that with respect to Thermo and the other parent companies, I think the one thing that the trial court did not fully appreciate is that at the time the 4A claim was made and the suit was brought, not only was the law unsettled as to whether there was joint and several liability for defendants or respondents in the situation where the plaintiff property owner believes, as the jury found, that it has a zero equitable responsibility. The law was also very unsettled with respect to the appropriate tests that would be used to determine a parent company's liability as an operator for its subsidiary's
I'm not so
facility.
sure about that, but the judge said and it doesn't make any difference in regard to Fisher. May I ask
Correct.
one question, please? That reminds me. Why, since you get 100% from Fisher, why are you continuing against TJA? I didn't understand
I'm
that.
glad you asked that, Your Honor. There's actually a significant difference of $600,000 or so that rides on it, and it has to do with the fact that certain costs, which are not recoverable under 21E because of the statute of limitations ruling, are recoverable under the contract claim. And because of the date of the breach of the contract, prejudgment interest also runs from a significantly earlier date, so a lot rides
So the
on
fact that the numbers are pretty close, at least as the jury found them, isn't the bottom line.
Correct, Your Honor. And the last thing I would like to say is we are seeking appellate fees here against Fisher, both under Section 15 and Section 4A of Chapter 21A. Thank you.
Thank you. Mr. Sablon?
Good morning, Your Honors. My name is Jonathan Sabloni, and I'm privileged to be here today representing all of the defendants, some of whom, as you've heard, are appellees and some of whom are appellants. Your Honors, Ms. Goodhart and I certainly agree that there is so much information and so many issues before you this morning, it would be impossible to even begin to cover it in 15 minutes. What I'd like to do, with your permission, is cover 2 or 3 major issues, which I think really make this case one that deserves your attention. The first is this issue of we've been hearing about regarding Mr. Rudman, and this is the Section 4A process. Because we have to remember and remind ourselves that this entire process is driven by statute. And that statute begins with what Section 4A calls the pre-litigation procedures. And those include a demand letter, is the start of the process, by the plaintiffs to the various potentially responsible parties, outlining a number of issues. One is, of course, a factual basis for some type of claim. The other is that the facts are supposed to be on target and made in good faith in that letter, and of course, to the extent they can be, as particular as possible. Then the plaintiff is also supposed to include a number of other things in that letter, one of the most important of which is a proposed equitable share between the parties. And let's focus for a minute on equitable share, because we haven't heard a lot about it.
But if the plaintiff doesn't know because it's not in possession of the material and the defendants or the putative defendants do know, then how much can the plaintiff do?
Your Honor, I would suggest that what we've heard about them not knowing is more argument than fact. If you look at the record in this case, this is not the case of the so-called innocent landlord, which is a term that's often thrown around, where somebody comes in, purchases a piece of property that's already contaminated, and then becomes strictly liable because they're the owner of the property. This is a case where the Lincoln Street Trust, which is a subsidiary of Massachusetts Mutual Business Trust, which eventually is a subsidiary of various insurance companies, including Arkwright, purchased this property back in the 1950s, developed it from an apple orchard into a manufacturing facility, remained the landlord the entire period of the lease we're talking about and reaped the economic benefit of that property during all those years of the various different
Okay,
tenants.
I understand that it got money from the lease, but that doesn't mean the landlord doesn't know what goes on with the tenant necessarily.
Your Honor, I would disagree because the evidence showed that the landlord had facilities people on site during that entire lease term who knew the facilities. Some of the facts we got in discovery came from the plaintiff's own former employees who had been facilities people at the time. In fact, this case might be even a unique one where the plaintiff, the landlord, had more information than some of the defendants because we heard about these sales and these spin-offs and these mergers. In many cases, these were so-called turnkey sales, meaning they were asset sales where the documents were left behind. So a company like Fisher that hadn't been involved in the property for over a decade had very few documents related to this property, whereas the plaintiff had done a 12-year investigation at the time.
Fisher had documents about the TCE, didn't it?
Fisher had some documents about the TCE.
I mean, it was its TCE, wasn't it?
It was, Your Honor. I'm not suggesting it wasn't. I'm simply saying that
And I mean, Fisher must have known that it used the TCE and that it released the TCE.
Your Honor, there was, believe it or not, it did need to be some in-fact investigation by Fisher at the time to determine what had happened because, first of all, there were a number of Fisher entities, and the question was which one are we dealing with? And then the second was, given these turnkey sales, what was going on at the sites? Ironically, a lot of the documents that were found in this case relating to the use of TCE that finally put some context and color to all this were at what was then a completely different company, which was Allied Signal, because there had been a parent at one time and then other things had been spun off.
But it was still a company. It wasn't the plaintiff's company. It was one of the defendant's
No, that is
companies.
correct, Your Honor. But all I'm suggesting is the plaintiff did not come into this investigation blind. The plaintiff had facilities people who had been on site. The plaintiffs knew who the tenants were over the various years because they were the landlord. And they certainly knew that TCE had been used at a certain period of time.
But if you think that the purpose of the statute is to get somebody to immediately take action, response action, and then later to sort out the liability, and if you want to further the purpose of the statute, how does it do that? To make the plaintiff dig out who was responsible to what extent when it's really, if all the tenants got together, they could have figured it out.
Let me explain, Your Honor, if I can, why it matters and why I think it does make sense. First of all, the statute puts that burden on the plaintiff. The statute says the plaintiff sends the demand letter. The demand letter should have an equitable share. Everybody is strictly liable, including the plaintiff, who either used and stored or owned. The reason equitable share mattered so much in this particular case is because you had various parties who were not related at the time, all of whom may or may not have had an equitable share, and were looking to figure out who's going to fund what. Because in this case, you had the plaintiff alleging that Thermo Ash at the time had used and stored TCE. We now know, through Mr. Rudman's testimony, that that was a false allegation. And let me put a little bit of context on this. This isn't a question of credibility. It's simply a question of timing. Mr. Earl Lewis was the CEO of one of the Thermo entities at the time. He made that statement and said, well, we may have. He didn't know. But more importantly, he made that statement back in the 1980s. By the time Mr. Rudman sent the demand letter, it was 1995.
He was the vice president, wasn't he, not the CEO?
He probably was the vice president. I'm sorry.
But,
I
Mr.
misspoke.
Savoni, I mean, as between the plaintiff and this series of defendants who are successors under the lease, I mean, if you're going to choose, why is it that's the plaintiff's problem?
It's not a question of choosing, Your Honor. It's a question of deciding how you're going to work out an equitable share among a number of potentially responsible parties. And when you include a party like Thermo Ash that had no liability under 21E because they'd never used or stored a hazardous substance at the site, you make that process impossible. Because Fisher does not know that TJA didn't use and store. They're taking...
But TJA must know it, and if you...
TJA did know, and they said we didn't do it.
Okay, but
and the
how
plaintiff
is
said,
the
yes, you did.
plaintiff supposed to know that?
I'm sorry?
How is the plaintiff supposed to know which and who did what?
They did know because Mr. Rudman admitted that he knew because they did an investigation, which included facts as well as subsurface drilling. So all I'm suggesting, Your Honors, is when you make a statement that's inaccurate on its face in a letter, even though it doesn't involve Fisher, it involves Thermo Ash, Fisher rightly says, well, wait a minute, now we've got 2 or 3 or 4 different parties who used and stored. What's the equitable share? And the plaintiff's position was, you go work it out amongst yourselves. That's not what the statute requires.
But are you saying that the record actually shows that Rudman actually knew that TCE was there? Or are you saying that he should have known because they had maintenance people there and were doing drilling?
Your Honor, the record shows that Mr. Rudman knew the TCE had been used on the property prior to 1986 and had stopped being used after 1986 when Thermo Ash assumed the lease at the site.
But
And
there
I
is
can-
this issue about, as Ms. Goodhart said, about derivative liability.
Your Honor, that is, in my view at least, a red herring. If you look at the demand letter, it doesn't say derivative liability. It says used and stored TCE. If you look at the complaint and the amended complaint, there are specific allegations that say Thermo Ash used and stored TCE and is therefore a liable party under 21E. The first time, the very first time, derivative liability showed up in this case wasn't in the complaint, wasn't in discovery, wasn't in the various summary judgment phases. It was on the eve of trial. That's the very first time. You can scour that record, and that derivative liability argument does not appear. The complaint alleges use and storage. And we have an admission by the attorney who signed the demand letter that he knew that TJA had not used and stored TCE at that site. That's bad faith. And when you start off the process in bad faith, it's not surprising that you don't get a result pre-litigation that you might want. The other part of that in the 4A process is the plaintiff's attorney's demand at the 4A meeting to say, here's what we've spent so far, it was around $550,000. I don't care how you do it, you folks all go out, figure out how you're going to pay me 100%, figure out how you're going to pay me 100% going forward, work it out amongst yourselves and write me a check. That's not a negotiation in good faith. Because at the time, everybody knew that $550,000 was not an accurate number.
Okay, if you, even if you take umbrage with how that was, that condition, or those conditions were put forward, why could you, the defendants were all sophisticated business entities, well represented by good lawyers, as witnessed here now, why couldn't they have come back with a counteroffer? I mean, you don't have to sit there silent in the face of an offer you don't like. I'm sure you've all experienced that before.
The testimony in the record, Your Honor, and there were about a half dozen people at that meeting, and the testimony from everybody at trial about that meeting was that everybody believed the plaintiff's counsel. He was that convincing, that at that meeting, everybody said, we believed he wanted 100%. And the testimony was by...
But there were such things as counteroffers.
Well, I would say, Your Honor, that
But he got 100%.
I'm sorry?
He got 100%.
You know, Your Honor, he really didn't, because of that 550, close to half of it was knocked out by the time we got to trial.
Well,
when we talk
certainly
about-
there was
so I'm
no
just-
liability on the plaintiff's part.
Yes, what you have to put yourself back in 1995 before the trial. You can't, with foresight, know that back in 1995. You know that it's just, the jury would have been perfectly allowed to give the plaintiff an equitable share in this case, given that they were the landlord through the entire period. And you also have a number.
Okay, so you make that as part of your argument, and you come back with a counteroffer. The statute contemplates some sort of negotiation in good faith, and if you don't like what the other side puts forward, why do you do nothing until after suit is begun?
Your Honor, the statute has two provisions. One says a negotiation in good faith, and that's not really where Judge Billings went off on the Section 4A area. There's a second piece of it that says that you can be awarded litigation fees as a plaintiff if liability is reasonably clear among a defendant and they fail to enter into an agreement going forward. And I would submit the issue is not whether there was an offer or counteroffer, because the statute doesn't require offers or counteroffers. It requires a negotiation. The issue we're talking about is why was not an agreement entered into. And I would suggest it takes 2 and maybe 3 or 4 parties to enter into an agreement. There could not have been an agreement following the 4A process, given the misstatements of law, the misstatements of fact, and the negotiating posture of the plaintiff at the 4A meeting. It cannot happen because you have multiple parties with differing interests who are all essentially being lied to, who are being told this party used and stored when it didn't, who are being told you parent companies here, your liability is coextensive and you are liable, you have to pay up. Everybody's arguing at that point about the facts and the law. If the plaintiff's position had been, we did our investigation, Fisher used and stored, sent a demand letter to Fisher, let's have a discussion, we understand that there's 100% equitable share here that can be split up, let's discuss it, this case may never have gone to where it went. But I want to move, and by the way, the question was, what is the testimony? The question to Mr. Rudman at trial, and then he affirmed it, was, at the time the letter was sent out, the demand letter, did you know whether the statement was true, whether there was use and storage after 1986? I knew that the information we had received was that TCE had not been used at the property after 1986. And is that testimony true today? Answer, yes, it is. This is the lawyer who not only signed the demand letter, but who managed the response action and now we're going to argue about whether his fees are recoverable.
There's a very good argument there, but what do you do with the principle that the credibility of the witnesses is up to the judge, and the judge simply apparently did not believe Mr. Rudman and credited the plaintiff's testimony?
I would suggest, again, Your Honor, it's not really an issue of credibility. It's once again an issue of timing. By 1995, the facts were developed in a way that they weren't in 1988. Mr. Lewis said May. He didn't have firsthand knowledge, and it was 1988. By 1995, there had been 7 years of subservice and factual investigation. Mr. Rudman did know. And if there had been other testimony, it would have been presented at trial and we wouldn't have ended up with this, other liability argument under 21E for TJA. But, Your Honor, there's another equal piece of this which is disturbing, at least from Fisher's standpoint, on the 21E phase, and that is the judge's jury instruction. And here, even Judge Billings admits he's making law. So whether we're going to agree with Judge Billings, which I submit you should not or not, we have to understand that there is new law being made here. The statute under 21E Section 4 is very clear. For a private party to receive response costs from another private party, they have to show that the response action was conducted in accordance with the MCP. That is what the statute says, period. Judge Billings gave a jury instruction that said, and I have it right here, the burden is on the plaintiff to show by preponderance of the evidence that its response action was conducted in accordance with the MCP. If Judge Billings had stopped there, we wouldn't be here today. Instead, he went on to say, that doesn't mean strict compliance or perfection. An immaterial or insubstantial deviation from the MCP would not mean that the response action was not conducted in accordance with the MCP.
The Attorney General disagrees with you, right?
Your Honor, I saw that, and I have to tell you, frankly, as a citizen of the Commonwealth, I was shocked that the Attorney General would say that the DEP certainly takes the position that you have to comply with the MCP when they conduct a response action. And in fact, in this case, the plaintiffs were audited and cited for noncompliance and made to do it right. What the Attorney General seems to be saying is that if you do it incorrectly, you can still go recover from a private party. I would submit two things. One, I don't think that's good public policy. And two, I don't see how the Attorney General's view has any role as between two private parties, especially when the DEP...
Well, I'm just really talking about interpreting the statute and, works with the statute.
And I will say, in terms of the legal issue, that is the first time I've ever seen an argument that you didn't even have to follow the MCP. That's certainly not the position of the plaintiffs.
That's not fair. That's not what it
The
says.
instruction is a minimal deviation doesn't matter.
Yeah, just you talked about the
I don't
minimis,
see
isn't he?
anything wrong with that.
Excuse me, Your Honor, we're talking, I think, about two very different things. If we can talk about the jury instruction, absolutely, and that's not what I meant to say about the jury instruction. I was referring to the amicus brief that the Commonwealth filed, which has a position in it that says you don't necessarily have to follow the MCP. It's not necessarily dealing with strict compliance versus perfection.
Now,
Let me just...
your time is up. Thank you.
Thank you, Your Honor.